at 7.
Most of them start at 6:30.
Do you want to, we could even do it in line with those, so there's no, do you want to, we could do Wednesday at 6:30.
Yeah, it makes it easy because it was 6:37.
That's usually the day we have finance meetings.
Yeah.
Well, we would have to do, we'd have to schedule it, and I know
Yeah.
Steve.
This week wouldn't be finance.
No.
This week is finance.
Right, so we're usually in the, what, 3rd week? And safety is in the 4th, and you're in the 2nd. So 2nd, 3rd, 4th.
Your public safety is tomorrow.
Which is unusual, because we're, right.
However,
So-
in August, we moved it to the 3rd.
So I will consult with Carly, and if there's no objections, I will move it to the 3rd Wednesday of the month, right? Because that's, I think I'm right about that, at 6:30. And we will be consistent in line with all the other meetings that occur on Wednesday at 6:30.
Can you just, when you,
I
I'm
promise,
not writing anything down until you run it by Carly.
I will run it by Carly, and then I will confirm it.
Use it 3rd Wednesday.
Yeah.
Okay? So a special meeting on July the 6th at 7 p.m. where we will address substantive issues. I will put, can I put this up on the website so the public can access it, the proposed reform?
I have no problem with that, but we're starting to address those this evening. Mary Ann had a number of questions, so we can get started with that.
Okay, I'm going to give you the floor for general questions, okay?
Who crafted this amendments and these laws?
Corporate counsel is the quick answer.
Yes, our office drafted it.
Last time they drafted legislation, there was conflict. It was not transparent.
Okay, transparency is a...
You have provisions in your budget to hire your own counsel to get their opinion on this situation that's here.
Duly noted. Conflict of interest. Okay,
I've
duly
been there
noted.
before.
Can we,
Mary Ann,
thank you.
you have the floor.
Thank you. Okay, my question, I just need clarification of this because I'm not sure.
Yeah.
Would there need to be a charter revision? Because when I went to the press release and the mayor spoke in regard to the ethics, and he said that they would not serve at the pleasure of the mayor. So he didn't feel that that should state that language, so.
Our opinion is that there does not need to be a charter revision in order to implement the appointment process that is set forth in this proposal. Ultimately, the appointments are made by the mayor, and that's what the charter indicates.
Right, but this is changing.
No, it is. The
Okay,
appointments are
continue on.
ultimately made by the mayor. The mayor is going to seek recommendations with regard to 3 of those appointments from the council. But ultimately, the appointment is his. So it involves you in the process, but it doesn't make you the appointing authority.
But he did, okay, so that's what I needed clarification of, because he specifically stated at the press release that he didn't feel that it should be served at the pleasure of the mayor, so that's what I needed clarification.
And he doesn't, but, you know, the fact that he doesn't believe that it should be is not the same as saying that we can do it without, you know,
So since it doesn't say that specifically in here now, it doesn't require,
No, it does specifically say in this proposal that the appointments are made by the mayor.
Right, I saw that, but it
Right.
doesn't say that they serve at the pleasure of the mayor.
His practice will be that he will consult with us. The problem is
Correct.
it's not codified in law.
Right, and it doesn't.
Right, so if another mayor comes in and doesn't want to consult,
Well,
But there's other sections of the charter and code that XYZ serves at the pleasure of the mayor, so if we're changing it and one doesn't have to be changed throughout the whole charter, that's it.
we do not believe that that is a problem. We believe that this is fully consistent with the language of the charter, and that, you know, any challenge to those appointments would not be successful. That's our position, and we believe it's consistent with.
And I'm not questioning your
No, no.
belief, but that belief is from where? From just a conversation,
From a
or is it
review
legally
of,
somewhere,
from a
or?
review of ethics proposals and ethics bills from municipalities throughout the state law, and basically reconciling, all of that legislation. We do not believe that there needs to be language in in this legislation that says that they can be removed at the pleasure of the mayor, and we believe that including that language is inconsistent with the intent of the legislation, and in many respects puts the mayor in a class where he cannot be subject to the ethics law. Because if he was subject to a complaint, he could just remove the members of the board that are opposed to whatever he is or is not doing. And that is inconsistent with the intention of this legislation and ethics legislations in general.
Okay. Am I still going, or?
You can go.
Okay.
We'll let you.
My next one is where it is in section 13-3.
And just before you ask that, in terms of the section numbers, the numbering, the subparagraphs are going to be changed. Okay?
But for today.
For today, the substance is what we're focusing on.
Well, I wanted to try to bring you where I'm going.
No, I know, and I'm just saying because it's,
Okay.
it's torturous to find sections based upon,
Okay, so then K, number 3,
K3.
where it says officers or employees,
K1, 2.
I'm going back to the first.
shall not display, distribute, or other, am I in the right, are you with me? Anybody?
Yeah.
I'm trying to
Can
find
you give me
it.
a page number?
There's no page number.
No, just count.
I will count them.
K3, I think I got it.
5.
Officers shall not display, distribute, or otherwise utilize election campaign. Okay, yes.
So officers or employees shall not display, distribute, or otherwise utilize election campaign literature or materials at a city workplace. However, this prohibition shall not be construed as prohibiting the wearing of small lapel pins by any person.
Yeah.
And I just want to verify this because I marched in the Memorial Day parade, and is that a function of the city of Kingston? Because there were people campaigning there, and I don't think that's respectful to.
Well, it's not a city workplace.
Okay, so
It's
that's.
a public street.
Okay, but okay. But I know it was brought up, and the mayor did have to ask them to.
Right, whether or not it's
But is it
permissible
something that
for other
should be in
reasons.
here, or no?
I would have to look and see if it's covered under anything else. I think it has more to do with, rules related to,
Political campaigns.
public present, public events, and.
I know the children's parade just
Yeah,
sent
it's
out.
not a city workplace, and
Okay.
as such, it's not covered by, that subsection.
Okay, next page, Q, with recusal. In the past years of serving, some people have recused themselves, and they've been asked to make a statement as to why they're being recused.
Yeah.
And other people have recused themselves, and somebody has stood up and said, can we know why you're recusing yourself? And the president at that time said, that's not necessary. So it's gotta be one or the other. We recuse ourselves and say why we're recusing ourselves, or we recuse ourselves and nobody has to say why they're recusing themselves. Because over the past 5 years, I've seen that as an issue where some have to, some don't have to.
And we agree wholeheartedly, that's why it's in the legislation, where it says specifically, must state that he or she is doing so at a public meeting on the public record. The
Okay,
officer
so-
shall- right.
So we,
Whether they do not have to explain it further.
so if I say, just say, it's, a stop sign. I'm just using it.
You're gonna recuse yourself on a stop
All
sign?
right, what am I gonna use? But I wanna recuse myself.
Well, if you have to recuse yourself because an issue related to the hospital comes in
Okay.
front of this board, I mean, let's get down to what we're really talking about.
Okay.
Okay, because that ties.
Well, mine
other
goes even
provisions
deeper
in.
than that. If I had to recuse myself from, the night shift plan, because
Yeah.
there was legislation on that.
Right.
So I just stand up and say, I am recusing myself this evening from this resolution. Is that it, or?
That is, according to the language in this proposal, that's all you have to do to be in compliance with the ethics code.
Okay.
Again, that doesn't mean that pursuant to other, rules that are applicable to you as a public body, you don't have to give more of an explanation. Okay, the open meetings law has very specific, provisions that are not necessarily ethics provisions, but they still apply to you as a public official. Okay? So according to the ethics law, all you have to do is recuse yourself. You have to state that you're recusing yourself. Whether there's some other regulation that requires more than that,
I was just looking for consistency.
Is that in the rules
Yes.
of the council?
It could be in the rules of the council.
That's where it should be clear, you're right, it should be
Right.
clear.
Yeah, I believe it's also covered under the open meetings law. But
Okay.
again, that's just off the top of my head.
Okay, next page. It's under 13.5, Board of Ethics. I do have a question in regard to where there is a conflict of interest, that Corporation Counsel would have to seek outside counsel
Yeah.
in the amount of at least $10,000. Does that come out of the already designated budget line of the
Well, that's a deal-
25,000? Or is that the
If-
common council's budget line?
There would need to be a finance committee discussion with regard to that issue.
Okay.
The reason we came up with the $10,000 and made it a stable replenished fund is so that there is money there in the event that a conflict comes up. And that is because the last time this issue came up, outside counsel cost in excess of $10,000. And we were left scrambling to find that money, and my recollection is it ended up coming out of our budget.
Yes,
Out of our outside counsel budget, and we don't necessarily have a problem with that, but we wanted a dollar amount specified that accurately reflected how much one protracted proceeding had cost us in the past.
And I retract what I said, that is, that we had proposed 25 at
And we
budget
bargained.
time, but we bargained it down to 10. So right now that outside counsel line is at 10. Would there be a new budget line added? Because that, I thought that 10 was specifically,
That was theoretically for a conflict counsel for the common council in the event you had a conflict. Okay, this is an additional, right, this is an additional expenditure
So it would have
that we
to be
are asking, that we will ultimately be asking, finance to put in the budget, whether it's in a separate line or whether, it's, in future years, it's a separate
so
line.
we would
in
wait till
addition-
budget? That would be awesome if we waited to budget to put it in the event that we needed it.
We go back to timing here, okay, and the issue as to why we want this process started. Realistically, this is a local law that's gonna take 2 readings. Realistically, we are not gonna have this in place, assuming there aren't any significant changes, until September at the earliest.
Because I
So,
don't like the idea of adding a new line and looking for $10,000 and taking it possibly out of contingency. I
that
think
certainly doesn't surprise us.
And, so I like the idea that
And there is nothing pending
September
at this
that it
point.
will be,
There is nothing pending at this point. We don't know if something will, be raised between now and the end of the year that's gonna require that
Yeah,
kind of
beginning of
expenditure.
the next
We're gonna
budget.
have to play it by ear, the same way our office, will, periodically comes to you and asks for, replenishment of the line in our budget for outside counsel. It's the same sort of thing. We don't know if it's gonna happen. We hope it doesn't happen because, again, the previous ethics board handled very few complaints in the time that it was in place. There is nothing pending now. And and there are very limited circumstances under which our office cannot provide most of the necessary legal advice to the ethics board. The issue is when, under the Attorney Code of Professional Responsibility, there is a conflict that precludes us from going forward. And there are provisions in this bill to address that, and there are basically like triggering mechanisms, shall we say.
okay. All right, then letter B2, at any given time, no more than 2 ethics board members may be registered in the same political party. And we have 5 board members, right?
Correct. And that's something that was in our previous, code, It's something that appears in the vast majority of codes throughout the state of New York. The presumption that
So then you have-
that the committee should not be dominated by, should not be a tool of any political party. So you can have 2 Democrats, 2 Republicans, and a non-enrolled. You can have 5 non-enrolled,
Or an independent.
exactly.
Okay. Let me just flip.
I think, you think that's unworkable?
Well,
Because we have a 2-party system.
Well, we really don't anymore.
no.
Everybody else's party's got something.
And you have a whole lot of people not registered in any party, and basically what we need is conceivably you could have 2 Republicans, 2 Democrats, and a non-enrolled.
I just want to clarify, because I think you meant something more than that. You said you wanted to clarify, but I think you have some other point. Is that right?
Well, I'm thinking, is it gonna be 1 Democrat, it can be no more than 2, but 1 Democrat, 1 Republican, 1 liberal, 1 Green Party, 1, does it have to be 1 of each, or we can go up to 2?
It says no
Probably
more than 2.
Okay.
You can have 5 non-enrolled people.
Would-
Yeah.
Okay.
That's not a political party.
Yeah, it's not, but that's, it's semantics.
Yeah.
Maybe registered in the same political party, so they're not registered in any political party.
I'm not going to argue with the language, I'm just saying it's semantics from my view, because if they're 5 unenrolled, they would tend to share a certain political perspective.
Yeah, it's go- yeah.
Are you done?
Right now I am.
Okay, I'll come back to you, I promise you.
I think I'm okay right now, 'cause
So Rennie had his hand up, and I'll be here, and then, yeah, go ahead.
That is a more general question. I was wondering if you could tell us what your sources were for creating this. Was there one particular ethics code that you thought was a really good one from another town? What might be a way for us to look at, say, another one to compare to see how we stack up with another city that's somewhat like ours?
And I know we had this conversation with regard to the last issue. If you go online to E-code, pretty much every municipal code in the state of New York will come up. And you can
And so it's going to be
browse-
under that same set of,
E-code, when you sign into E-code, there's a search bar up on top, and if you just type in, ethics, the various codes will come up. In terms of sourcing, I can't tell you how many we reviewed, but it was many. I would say at least 10 to 12 minimum, ranging in all sizes. In terms of the municipalities, what we ended up focusing on was finding a code that addressed the most problematic issue that we have had, which were the disclosure forms, the processing of the disclosure forms, and the FOIL requests with regard to the disclosure forms. And the one we found that was the most comprehensive, that we thought was the most appropriate, was the Saratoga Springs. But we basically built out from there, because there was a very detailed, comprehensive language with regard to the processing of the disclosure forms and how issues are evaluated. Was that?
No, that's okay, Dan. Good evening. For those of you who may not know me, my name is Jean Jacobs. I am certainly not here this evening as the Ethics Board Chairman. I am no longer the Chairman nor a member of the Ethics Board. But I just wanted to do a little at a glance, because I recognize the importance and the job that is ahead of you in redesigning and going forward as I'm listening here this evening. But quite frankly, just a little bit of knowledge, and that's why I'm here. I'm all about education and educating the community. In June of 2013, the board, or the Common Council, approved the current local law 1, the ethics law. And in July of 2013, that was processed and sent to the state via the fact that the state had sent down the recommendations that an ethics law had to be created within the city due to circumstances, as we all know, that was going on at the state level. Therefore, in July, that took place. How many of you were on the council in the creation of the current ethics law? I know many of you were. We move forward, I'll be quick. In January of 2014, the Ethics Board came, there were 5 of us, very respected members of the community. Mayor Gallo did appoint all 5 of us in the summer of 2013. January of 2014, our first claim came before us. Alderman Will, had to do with Mayor Gallo. We met, Mr. Gardenstein, attorney, corporate counsel, came to the first meeting, and he could not represent, but he did, that was our very first meeting, so he more or less instructed us due to the fact that corporate counsel could not represent the case, and we had to go to an outside attorney via the law, which we didn't. There was no probable cause, and we moved forward. During 2014, as Attorney Gardenstein said, there were not many more violations or accusations during that year. In 2015 of January, there was a claim, Andrew Champ Duran, and we all know the case there with Alderman Will. In February of 2015, you amended the disclosure form because the one disclosure form was too involved. You wanted a simpler form, and therefore that was created and it was amended. Okay? Moving forward, in April of 2015, John Perry with the Pike Plan Commission, he filed a claim. Okay? And that was again with Alderman Will. Moving forward, in May of 2015, the disclosure form should have been filed. I questioned it here within the city. As the Ethics Board Chairman, it was critically important that we found out because we were responsible. That did not come to fruition. There were 14 to 18 that were completed at that time, but in excess of going above 50 that were not. I was concerned, and so was my board. Moving forward, we went into the summer. I'm trying to stress a point here. The Ethics Board, there were minimal claims, but the amount of work was astronomical. I cannot begin to even get into that here this evening, of what was required by us as a board. Okay, we hired David Clegg as an attorney. There was a conflict. We hired Attorney Sussman. Went on for months, and you're aware of that. Some of you, if not all of you, are aware of it. The end result was there was a hearing and probable cause was founded. But the major part here is we followed the ethics law explicitly because that's all we had. That is all we were given. We didn't design it. We didn't create it.
Okay, I'm gonna ask you to
Okay,
sort of wrap
no,
up.
I'm done. And so therefore, what bothers me now considerably in faith in public trust is that we don't have an ethics board, and certainly I've done my job in my board, and virtually we're redesigning the wheel, which is fine if you feel the need for that. But I'm a concerned citizen.
That's fair enough.
And you know what? And I'm a concerned, and I'm sorry if I've taken your time. I've heard others take time here this evening.
No,
and
we're trying to get to the substance of this issue, okay? And it's not actually a public hearing, so
No, I realize
I'm
that.
giving you the leeway to speak here, and I'd appreciate it if it would be germane.
Okay, but I also heard that the law was haphazard. It was told by, that's absolutely unheard of when we were trying to serve the public.
Okay, that's not up for debate here.
Okay,
Well,
no,
let me jump in just for a second, Jim.
Yeah.
No one is saying that the board did not apply the law as written or in any
No, of
way
course
did
not.
not, follow, and fulfill their responsibilities. The issue really relates more to the substance and the ambiguities and the problems in the law that you were asked to enforce and apply. And that law was passed under circumstances that a number of people at this table can attest to, did not lead to a product that was workable. It was more, a political battle, and an attempt to secure credit for one party claiming they were more ethical than the other party, and it never had anything to do with developing a piece of legislation that was workable for this community. Nina's over there looking at me like you participated in this, you remember. Billy remembers, Yeah. So nobody is in any way faulting the job that the ethics
No,
board
of course
did.
not. I'm not saying that. I didn't come here to say that whatsoever.
Well-
I said we had a law we had to follow.
You know,
And you did.
we have some substantive
Yeah.
issues here. I want to get to the aldermen, and then if there's time permitting, I will return to.
No, I'm good, I'm passing.
You're passing?
And I'm gonna go back to my seat, I'm sorry, we're back to you, Gina.
Okay, I have an issue,
Okay.
and I don't want it to be a political football, but in 13-5,
Okay, hold
the
on.
last sentence,
I have to sign back on that,
okay,
give me 1 second.
13-5A.
13-5A. Yes.
For the very last sentence, it says, "In the event that the matter involves the mayor or a member of his family or household, as those terms are defined above, the alderman at large shall act in the mayor's place." But as we currently know now, the alderman at large is a family member.
Well, he's actually not as the term is defined in this code. If you look above under definitions,
First page.
yeah, under the first page, he is not. He's not a member of his household, and he's not a member of.
But he's stepping into the mayor's place, that was the issue.
Right, but he is not, but what I'm telling you is that according to the definitions, he is not a member of his immediate family.
Includes
and he's
spouse,
not a member of
domestic
his
partner,
household.
sibling, parent, children, grandchildren, the spouse of any of
He's
them,
not-
and any member of the
I know, but he's
individual's
taking
household.
the role of mayor if there's an issue with the mayor. Is that what this is?
No, no, that relates strictly to, if you go back, hold on a second. That relates strictly to the approval of the retainer agreement that is required for outside counsel. Strictly limited to that.
Because it's under-
Basically, one of the-
But that's a different section, the
No,
other
it's-
section.
No, it's in the same section.
Oh, it's in the same.
Such retainer agreement shall be
Okay.
subject to the approval of the mayor, because we didn't want the retainer agreements to, to be insane and have no check and balance. Our office clearly can't, review it and determine whether or not it's appropriate, because the reason you have outside counsel is because we have a conflict. Okay, so what we said was that the retainer itself would be subject to the approval of the mayor. And if the mayor is the one being investigated, then it would be subject to the approval of the alderman at large. As long as the alderman at large is not,
He's an uncle.
but he's not a family member, he's not a member of the household, and the,
But
you know,
it's,
the you can't
I know,
account for
but
every
it's
possibility with them.
no, I know, but the
I ask you a
perception,
question?
that's the
Can I ask
issue
you a
I was just
Yeah.
saying, so.
Well, it would be a political issue.
Right,
It
and
may
I'm
not be
trying to
legal.
avoid that,
Right.
I'm trying to avoid that.
You know what, there is nobody else in the structure of city government, okay, that you can assign that task to.
Not the majority like they do in the Senate or Congress? Just curious, because in the federal government, it
And
goes,
then what if the majority leader hypothetically is the mayor's, uncle?
well, I'm just saying it,
You're looking at putting, we're looking at putting together a statute that is not
But it's still-
specifically targeted. I mean, listen, you could say the
They're-
chief of police, you could say the director of public works, you can say anybody, but, the alderman at large, under the charter, acts in the mayor's, stead when the mayor is not available, so the appropriate person is responsible for himself.
I know that, but,
And it's just to approve the retainer agreement.
okay.
Yeah, that's all it's for.
Now, the alderman at large is involved through them, but just curious, What's the next person that rises to the, because I never could figure out in the charter, if there's an issue, who's the next one to step into place after alderman at large?
You.
No, I'm the minority. I'm just curious because.
There was no
both
easy
of
way
them.
to address that under the circumstances, and leaving it just as subject to the approval of the mayor begs the question of what happens if it's the mayor. So we put in a backup provision. Again, the chances that that's going to happen are pretty much slim to none. You also have to remember that most retainer agreements are pretty standard anyway. So, we're not talking about a significant responsibility under the circumstances, just so that someone has oversight.
But I just want to make that clear because that could be political, bad for everybody.
You mean?
It says that each board member shall be appointed to a 5-year term. I think that should go to a 4-year term. In similarity of that they shouldn't serve beyond the term of a 4-year term of the mayor?
And they talk about staggering.
What if they're appointed like in the middle? Because you're gonna have that overlap.
You're already standard.
Excuse me?
You're gonna have an overlap anyway. If there's not like, it's gonna be at the beginning of a mayor's term, you're gonna have one 2 years into it, you might get it.
The reason
There's gonna be an overlap. no matter what.
But it wasn't,
It was 5 years before, before there was no term. And the reason we made it 5 years was because there were 5 members and we wanted them staggered. So one person is appointed per year.
but I still believe that there's concern that it should be, we're kind of setting a precedence for a 4-year term, that things shouldn't go beyond a 4-year term that a mayor serves. There's other legislation, so it was just a suggestion. That's all.
But this is frequent in federal government, for instance. People on a lot of committees are appointed to terms longer than 4 years.
None of our current boards are tied to the term of the mayor. They're all rotating terms. And obviously the premise is that they are independent of the mayor despite the fact that the mayor is appointing them. And if you look at the charter, this is consistent with the, with the terms and the language that's in there with regard to all the planning board, the zoning board, and the rest. They're staggered terms of whatever, 3 years, 4 years, 5 years, or whatever it is.
I understand the staggering, but I'm just saying, we're setting a precedence with other resolutions and legislation to use a 4-year term, that maybe we should look at it as a whole.
Because you're more
To not
comfortable
give
with, I'm sorry, go ahead.
No, to not give them more of a lengthy term than the mayor, you mean?
And then, can you just explain the disclosure, where the change is and what the process is?
Yeah.
Would these, let's say this, we were to pass this, as it becomes law, would we then be able to go back and look at the disclosures we've just turned in?
No. No. Those were submitted under the previous legislation that has absolutely no provision for review, opening, or doing anything. Okay?
Sitting there in perpetuity.
Yeah, pretty much. Okay, so if you look at, let me count pages for you.
Okay.
What number was that under?
I got 13 here, it starts with forms, annual disclosure forms.
So 6, 1, 2.
13-4. Okay, which lists the individuals who have to file, and again, that is still,
We took up, well, the old one we took up.
we've taken off a number of people who were previously on the list because we don't have the authority to require them to file, and because they don't have the discretionary authority that would,
So this is the updated one, we took off the previous one.
pretty
So-
much.
We got that.
Pretty
far.
much, and the Director of Economic Development and the Director of Community Development have been combined because that's the position that is currently in place. I still have to confirm whether or not there actually is a separate revolving loan fund associated with the KLDC, because those two may need to be, one of those may need to be eliminated. I think the revolving loan fund may need to be eliminated. So if you look at 13.5, which is Board of Ethics, and you look at the authority of or the responsibility of the Board of Ethics under, hold on. Under E, 3E,
E and E3.
right,
Okay.
3E.
Okay.
One of the responsibilities of the Board of Ethics is to review, index, maintain on file, and dispose of written complaints. Oh, hold on, I'm sorry. That's the
Oh,
wrong.
wait, I'm in
No,
the
that's
wrong.
the
That's the
wrong.
wrong one.
Is it
It's
in
in
the-
here somewhere. All right, H, review of list of disclosure statements. The board shall review the list of employees pursuant to must file the disclosure form. And H outlines what they are supposed to do with them. So that's all outlined there. There's also a section that relates to the disclosure of the or rather the release of the disclosure forms pursuant to a FOIL request, and that, if you look below under L1, with regard to completed disclosure forms, notice of any request for inspection will be provided to the city officer or employee. The Ethics Board shall review any request for redaction of information, which means the officer or the employee has the right to request that certain information be redacted. The Ethics Board will review those requests and will authorize redaction of such information in accordance with the provisions of the Public Officers Law and applicable precedent, which basically means, case law under the Freedom of Information Law, and that any decision with regard to redaction can be appealed to the FOIL appeals officer.
What would be an example that somebody would want something redacted, just for?
One of the things that someone might want redacted,
I mean, there's-
personal information with regard to their household composition, their family.
Okay,
you
that's
know.
what I wanted to know.
I mean, there's a whole litany of things. People may, if the disclosure form is asking for personal information about your children or about your spouse, you can make a request to the Ethics Board that that information be redacted, and then a determination will be made whether or not there's, precedent to redact it.
Well, we're not going to be putting that up. I thought we were going to try and eliminate some of that on the disclosure forms.
There's still tons of information on the disclosure form that people might find offensive,
So the board will open them each year that they're filed?
Yeah.
Okay. And are they under any kind of oath
No
of
problem.
privacy?
Well, they're public documents, again, and that's what, that's been the issue up until now, and that's why there are provisions in the ethics law for the maintenance of confidential information, okay? But if a request is made for access to records under the Freedom of Information Law, okay, that request will be, put, the individual whose records would potentially be disclosed would be put on notice. They would then have the opportunity to ask that information on the form be
That's what I wanted
redacted.
clarification.
That request would go to the Ethics Board, and, with, advice from, our office with regard to applicable precedent, they would make a decision as to whether or not the request for redaction could be honored.
Tony?
And so we got through all this, and what if, and where's it stating here what can happen to a person who does not do the disclosure form? Does it state in here what can happen to them, Dan?
It's a violation of the ethics law, and a complaint can be filed, and the ethics committee can address it.
And then they would make the decision what person.
What the proper penalty would be.
All right.
And we have to have that stated somewhere in here?
It's in,
Is it in there? Okay.
yeah, I mean, it's a violation, any violation of the provisions of the law, is, referred to the ethics committee for action. And I mean, any provision, you don't differentiate, this as opposed to.
Let's see what the penalty. Did you see
I was one of the ones that did do it.
It goes under, back to violations,
Violations? Hold on.
which is under 13.3, I think.
Okay, so that's what I saw.
I think.
And just, to highlight other issues while people are processing whether or not they have any other complaints, any other questions? Whatever.
Freudian slip, right? It's getting late.
Okay. We rewrote the language so that, and there's been a lot of comments and issues with regard to the revolving door provision, and the premise is that this is a means to regulate the conduct of city officers and city employees, not members of the public. And once you leave office, you are no longer a city employee or a city officer, and therefore it is not for the city ethics board to regulate your conduct or to discipline you. There's a question as to whether or not there even is jurisdiction to do that.
That's kind of what I was alluding to.
Okay. So what we did was we included a provision that says that the city officer or employee cannot conduct business with an individual who has left, who is representing a particular entity, when that individual had a discretionary decision with regard to the issue before them. Okay, so the
Wasn't there a
onus is
2-year
placed upon the city
restriction?
employee or the city officer to not deal with the person who left, rather than trying to regulate the conduct of the person who left.
And the 2-year, wasn't there a 2-year something on that previously?
Yeah, that's
That's been, okay.
Yeah, that's been eliminated, based upon, again,
Small town USA.
yeah, and the fact that it's just not workable in a community this size. So there was, we're addressing the issue that has come up with, Tony in the past and potentially with yourself with regard to your employer communicating with the council, and you having to recuse yourself in every instance when your employer would communicate with the council. We have significantly softened that language,
Right, I
and we
saw
have
that.
also made it clear that that does not apply to employers who employ over 100 people when the city officer or employee is not in a management capacity. Again, recognizing the fact that, nothing personal, Tony, but
I could be management sometimes.
Well, it falls under outside employer or business, as well as,
the definition of customer or client.
right.
Okay, and our concern with that language initially was, it says any person to whom an officer or employees outside employees supply goods or services. Arguably speaking, every student in the school district receives goods or services from your employer, Tony. And under those circumstances, you'd have to recuse yourself on absolutely everything. In your case, anybody who received surgery at the hospital.
Anyways,
yeah,
right.
Right,
Well, me and Nina.
right. So.
Could you just clarify the role of court counsel of the mayor or a common council member goes before the ethics board?
Okay, you have to look at B1A.
Under 13.
Okay, start with B1A,
Okay.
which says specific city officers and employees. Okay? Officer or employees who are professionally licensed, except as provided in section 13-30 below. And if you go to 13.30 below, it ties back to where we started the conversation, which is that if you have a professional who is subject to a professional code of responsibility, their code controls with regard to how they conduct themselves. Attorneys in particular, our licenses are tied to our compliance with the code of professional responsibility, which outlines specifically when we can and cannot represent multiple parties in particular situations. And the focus of the code is on actual conflicts. So for example, I can represent two individuals in the same case as long as their interests are aligned. I can also represent two individuals if I am not providing advice in an adversarial capacity when their interests are adverse. So under these circumstances, as long as the interests of the two clients or the two individuals are aligned and there is no actual conflict, under our code, we can continue to provide counsel to both of those individuals. It is our responsibility under our code to recognize when a conflict arises, and at that point to recuse ourselves. And our licenses are dependent upon it, and we could not do anything other than that, regardless of what your code says. We have there is a committee on professional standards that processes any complaints or any questions that are raised with regard to our decisions regarding when we can and cannot exercise independent judgment. And there is a provision here that says that the ethics committee, when presented with that issue, that was your question.
It's okay. It's okay.
Okay,
It's all good.
that the ethics committee, when presented with that sort of question, has the authority to contact the committee, our professional committee. Or if it's a doctor, the doctor's professional committee, or again, I mean, if it's if yourself or Rennie had a situation where, a student of yours that you know personal information about that you can't disclose is appearing in front of the council asking for particular relief. Okay, you have to abide by, by FERPA, you have to abide by HIPAA, regardless of what this says. And if there's a conflict with regard to that, if somebody raises that issue, there are independent entities that can offer advisory opinions with regard to that, and this specifically authorizes the Ethics Committee to contact those professional organizations and secure an advisory opinion. That answer your question?
It does, because it's really, it depends on the context, is really what you're saying. And then I just want one last point of clarification, and that's about the composition of the ethics board, right? So if we wanted to reconfigure the composition of the ethics board, meaning who gets to appoint, and go to the initial idea that came from the mayor, which was the council would appoint some, the mayor would appoint some, that would require a charter revision.
Yes, sir.
Okay.
Eileen?
We exhaust questions? I'm going to let
Did
you
you know
have
what I
a...
asked earlier?
You did, I just wanted to clarify.
That it would,
In other words, you may have gotten that answer, but I just
I
wanted to
didn't think
clarify.
that it would not require.
It would, if we wanted to do what the mayor initially
As opposed to
suggested.
recommending.
Yeah, you had asked about the, and it's a related issue, but it's different. You had asked about the removal at the pleasure of the mayor as opposed to the appointment. Okay? The appointment authority is clearly set forth in the charter. Okay? And, we believe that needs to be adhered to, although we can certainly ask for recommendations and input from the council. We do not believe that the removal process is inconsistent with state law. That saying that there are criteria for removal, okay, is problematic. Mostly because the removal of an ethics board member, okay, would most likely be based upon a breach of the code of ethics. Okay, and it would basically be the equivalent of removal for cause.
So that's where you're saying the charter revision needs to be?
No. I'm saying that that if in order to change the appointment authority,
Right.
you would need a charter revision.
And aren't we changing it here with using the mayor and the common council?
No,
No,
because the
we'll
mayor is still the
recognize
appointing
this.
authority, he's just asking for recommendations from you.
But if we want,
I
You
know.
confused me on that.
I'm sorry.
It was a matter of recommending.
I was okay, then Linda said that, I'm like,
No,
wait a minute.
it was appointing versus recommending. That's where it tips, that's how we're charged.
Yeah, like we don't have authority. If a new mayor comes in and the new mayor's philosophy is different, then he can say, I don't need your recommendation, thanks.
Well, no, he still has to ask for your recommendation under the statute, then he can ignore it.
It's weaker than saying you have appointment authority, right? It's weaker.
my other question, one other thing, could we, or also eventually us, could we change this 5-year term, Dan? Because I know it was brought up, could we change
Could
this
you?
to 4?
Absolutely. I mean, there's, again, because it's a 5-member board, and because we are rotating the positions, and because we wanted one up every year, and because we wanted it to straddle administrations. We felt that the 5 was appropriate. The 5 was also, we thought it was an appropriate number.
I understand
I'm trying to figure
your
it out.
thinking, but I still,
You want it tied to elective terms. You don't want it to go beyond.
because if we're trying other things, but I think we,
We're talking contracts.
I know, but I think it's just something that,
I don't know.
I'm just,
I'm
go
not
ahead.
sure if we need to say it's tied to administration, it goes to who the mayor is, because re-elected, you can keep that same bunch of people on there. There's other people coming up to volunteer,
There's always
and you can
overlap.
bring another 4 people in with the recommendation of 3 of them being from us into it. So I just don't like that word tied.
There's always an
Because
overlap.
And he comes,
Just a thought.
it's 4 years, and the new mayor comes in, now they have that chance to get people that they might know who want to join, and still one overlapping. And if they get reelected, they can still choose. I mean,
Fair enough.
I like the 4 years instead of 5 years.
Do I have a second?
You adjourning?
I am adjourning. You will have time to speak at the special meeting on the 6th where you will have read the legislation.
Well, I wanted to ask you if the special meeting.
Fine, you I got your notes on it.
Is it gonna be anything like this meeting on the 6th? Because if it's gonna be like this meeting, it's not engaging public opinion.
You've had a lot of ways of being engaged.
I don't like it.
So, but yes, you will have time to speak at the.
No, I can-